In 1964, Duke Power Company, located in North Carolina, employed 95 workers. The plant had 5 departments: labor, coal handling, operations, maintenance, and laboratory. The labor department was the lowest paid department in the company. The highest paying job paid less than the lowest paying job in the other 4. In 1955, the company started requiring employees in all departments except labor to have a high school diploma. Before that, employees were hired into any department without one. On July 2, 1965, the effective date of Title VII of the Civil Rights Act of 1964, Duke added a policy that an employee wanting to transfer from labor into another department needed a high school diploma. It also established a policy that all new employees must pass 2 aptitude tests. Willie Griggs was one of 14 Black employees in the labor department. No Black employees were in any other department. He filed a class action lawsuit on behalf of himself and 12 other Black employees, alleging that the requirements for a high school diploma and satisfactory scores on the aptitude test discriminated against them. When the district court first heard and dismissed the case, it found that Griggs had not shown a discriminatory purpose to the requirements which was required. The Supreme Court granted certiorari, agreeing to review the case and hear oral arguments in December of 1970. Because many white employees who didn't have high school diplomas were hired before the requirements for the diploma or aptitude test, and those employees performed well on the job, it was clear the requirements didn't predict job performance. Duke Power didn't dispute this fact. The U.S. Supreme Court ruled unanimously against these intelligence testing practices in 1971. Chief Justice Warren Burger delivered the court's opinion that employers can use intelligence tests only if they are demonstrably a reasonable measure of job performance. The court found that a good intent or absence of discriminatory intent in the face of a job requirement that adversely impacts a protected class isn't a sufficient defense against discrimination. The job requirement must be shown to be job-related to be lawful, and it's up to the employer to prove this.